Good morning and welcome to the 13th meeting of 2025 in Session 6 of the Equalities, Human Rights and Civil Justice Committee. We have received apologies this morning from Maggie Chapman and Paul O'Kane. Our first agenda item this morning is to continue evidence taking on our civil legal aid inquiry. In this inquiry, the committee will be exploring what is working and what is not working within the current civil legal aid system and what changes could be made in the shorter and longer term to address issues about the access to civil legal aid. I therefore refer members to papers 1 and 2 and welcome the first of two panels this morning. We have Kevin Kane, Chief Executive, Shared Parenting Scotland, Fiona McPhail, Lecturer in Social Justice, University of Glasgow, Dr Marsha Scott, Chief Executive, Scottish Women's Aid, Sabir Zazeh, Chief Executive, Scottish Refugee Council. You're all very welcome this morning. We're just going to move straight into questions. And I'm going to kick us off. Last week, we heard from witnesses about the general barriers that there are to accessing civil legal assistance. Could I ask you each in turn about the specific clients that you represent and their specific barriers that you see in them accessing civil legal aid assistance? And I'll start with you, Kevin.
Thank you. We support mothers, fathers and grandparents after separation or divorce, and we're seeing an increase in demand on our services. Almost all are affected by access to lawyers and legal aid. We're seeing more parents in particular who feel they have a case to argue but can't find a solicitor to argue it. We've received calls from parents and grandparents in every part of Scotland saying that they phoned or emailed 50 to 60 solicitors without success. There's an overarching barrier that we see through our casework, and that's the adversarial system that creates an inequality of arms, which can affect the outcome of proceedings. What I mean by that is the better resourced client can wear down the other until they've run out of money. Their choice then, become a party litigant or walk away. Our view is that most people don't want legal aid. Actually, they want to solve their problems and get out of court. However, as it stands, it often requires going to court, at which point legal aid kicks in. For some, it's part of the solution, but also part of the problem, because it's bound to that escalatory adversarial conveyor belt that they're then on. As such, our meetings have pro bono solicitors at every one of them around the country. That's a positive, but it represents a fallout in the wider system. So we are seeing increasing referrals from other agencies, from agencies around this table as well, Aberlour, Children First, at local level in particular, with Women's Aid. On finding a solicitor, much was said last week. We would echo those comments around getting a solicitor to take legal aid, but an emerging and growing issue for us is clients who leave one solicitor and are unable to find a new solicitor to take on an existing case. Much has been said about the rural dimension, and we may pick that up later on. From our point of view, we've seen a more general attrition over 5 years, and that's due to solicitors having died, retired or just moved from one firm who did do legal aid to another firm who doesn't. So, in fact, I'll pause there just now. That's probably enough. There's things we could say about funding, but I'll allow others to come in. Thank you.
Thank you. Fiona, please.
Good morning, Committee. Thank you for the opportunity to be here this morning. I am no longer in practice, but have recently come from practice and spent more than 10 years there. So hopefully the evidence that I can share is of interest to this committee. Barriers for those facing housing crisis are several, and I'll go on to those, but I wish to start with the point that housing crisis and those with legal issues and housing issues vary, not just evictions, mortgage repossessions and homelessness, but we're talking about a good number of people who are stuck in damp housing, who have a need for legal advice regarding security of tenure. We have queries concerning discrimination in the context of housing. And the reality, the stark reality now, is that the majority of those cases that are deemed to be not as urgent as the eviction, the mortgage repossession or the homeless client as they're placed on the back burner. So in terms of barriers, the committee heard last week, lack of provision, and that is my starting point. There is a huge shortage of housing lawyers able to advise and represent tenants, homeowners, homeless people, people in housing crisis in this country. And those that are not in that priority category of facing an eviction hearing or on the streets are much further away to getting through the doors and accessing the specialist legal advice that they need. So housing law is a varied area of law. And secondly, I just wish to make the point that here this committee is concerned with access to civil legal aid, but that is just one part of the bigger access to justice picture. Access to justice doesn't mean much if we don't have legally enforceable rights and if people don't know about those rights. And Scotland can be proud of the very strong legislation it has for the homeless and for tenants across both social and private rented sectors. And law centres, charities and NGOs have done a great deal of work in campaigning for law reform and raising awareness of rights, but neither of those activities are typically funded by legal aid. And the legal aid lawyer is understandably increasingly concerned with the casework. So the activities that are required in raising awareness and influencing law reform fall by the wayside. As my successor, Ms Mayer, said in her evidence last week to the committee, the primary barrier here is the lack of provision. In their response to this inquiry, the Scottish Legal Aid Board highlights the lack of system-wide data as a weakness of the present system, making it difficult for them to target interventions for those who are unable to secure legal representation. And I wanted to provide the following data. I'm in an early stage of doing research here, but we do have data provided by the Scottish Court and Tribunal Service and the Housing and Property Chamber. And what we can see is that the increase of social landlord evictions is increasing. There's been a 21% increase in social rented sector evictions in the last year. In the context of mortgage repossessions, a 29% increase, and those cases are back to pre-pandemic levels. In the private rented sector, before the first tier tribunal, there's been an 80% increase in a 12-month period, and that was from their annual report of 2021 and 2022. The number of applications made to the tribunal for eviction in that year is a 29% increase on pre-pandemic levels. These statistics also tell us the following, that in the context of social rented sector eviction actions initiated, the landlord is 99.6%. In 99.6% of cases, the landlord is legally represented. That can be contrasted with 9.6% of defended actions where the tenant is legally represented. With mortgage repossessions, the lender is represented in 99.9% of actions initiated, and the debtor in the region of 9% of those defended actions. The Housing and Property Tribunal tell us, again for an earlier year, 2022 into 23, that 60% of landlord applications for eviction have representation against 7% of tenants. Now, I should stress that before the tribunal, it's not necessary to have legal representation. But I think the disparity in all three types of cases, even if we allow for a margin of error, should raise alarm bells in the context of equality of arms, as has already been stated here today. In all of these cases, at least one person, and there'll often be more in the household, is at risk of losing their home. And in the context of a housing emergency, when our local authority homeless services are at risk of systematic failure, this is of a great deal of concern. In 2017, the Law Society of Scotland conducted research on the social return of investment in legal aid, and then in 2017 found that for every £1 of legal aid spent on a housing case, there was approximately an £11 saving to the public. And part of that was about keeping people away from homeless services. And I'll wrap up with the two following points. We often look at England in fear, and there are no doubt grave concerns as to the reform of legal aid south of the border. But despite the stress in public finances in England in 2023, the Legal Aid Agency launched its Housing Loss Prevention Advice Service, which offers in-court duty on the day emergency advice and advocacy to anyone facing possession proceedings, and this service is not means tested. In Scotland, those at risk of eviction have to go through the means test as well as the merits test. Okay. I may say more later on grant funding in specific detail. Lack of provision it has to be the primary concern here. We can look at why there are not enough housing lawyers, and I'll happily elaborate on that point in due course if time permits, but it's the shortage at this point in time which is of greatest concern. Thank you.
Thank you. Marsha, please.
Morning, everybody. Good to see you all. I was looking back at my notes for this session and making notes for this session, and I realized that I have been in this building and talked about this issue many times, the first time starting in 2017. So I just have to preface all of my remarks with the plea that there is an appetite for action. I think the evidence is overwhelming from my colleagues here, from the colleagues at the panel last week, from the evidence that we have submitted multiple times to multiple committees over the last, 8 years. And there are some really clear tools available for quick action, but the whole system needs reform, as you probably all know. But we are no closer to that reform now, I don't think, than we were 8 years ago, and I'm deeply concerned about that. So I'm from Scottish Women's Aid. We're Scotland's national domestic abuse organisation, and we have, as our constituency, the women and children living with domestic abuse, experiencing domestic abuse in Scotland. And that sounds like a bit of a niche crowd, but actually we are the bread and butter of the justice system in Scotland. The more cases around domestic abuse that the police follow, we are the most likely reason for the police to be involved. So 25 to 30% of police business. We are 25 to 30% or more of court business. This is so important to understand that this is not a niche population, and it absolutely crosses over with all of the folks who are at risk of homelessness, who are made homeless by domestic abuse, by a system that fails to support them until they're destitute. And as a colleague has said about our the no recourse policy promoted by Westminster, it's destitution by design. So when you have a legal aid system that has the most farcical means testing mechanism in place in domestic abuse, where we know that 95% plus of the women who need help and who are experiencing domestic abuse are also experiencing financial and economic abuse, you have to wonder how sincere our attempts are to not only keep women safe in the context of domestic abuse, but to preserve their options so they don't wind up destitute, just trying to protect themselves and their children. So I will just use those as my overarching comments, I guess. In terms of our problems, obviously provision is a big problem. And we have talked quite a bit about the desert of legal aid services, and which is particularly acute in the Highland and Island communities, but it can be found everywhere in Scotland. And we have brought people into the Parliament to talk to ministers. We have done a number of things to try and make sure people are understanding how desperate the situation is. I think that the underlying problem we have in this argument, however, is that even if there were enough legal aid lawyers, and if they were paid whatever it is everybody agrees they should be paid, the model for legal aid in Scotland is not fit for purpose for domestic abuse. It chops women's and children's lives up into little bits, and it helps with some, and it doesn't help with others. So our experience is not only are legal aid lawyers not available, and it's a demand-led system for some people, but it is certainly not demand-led for the women and children we support. And it's probably the biggest violation of their human right to access to justice that I can think of. So the problem from our perspective is that it's not fit for purpose when it is available, which is so rare. We've also had women's aid workers in Grampian make 50 or 60 calls trying to find a solicitor. I mean, they gave up on a legal aid solicitor just trying to find any solicitor. And we've been working with SLAB, who have been really helpful in terms of setting up a referral assistance program to see if, since they know lawyers, go figure, to help try and connect women who are eligible for legal aid with a lawyer, usually a private solicitor. And that has been, in the best of cases, successful in about 60% of the calls that they get for the folks who are eligible. But that number drops like a stone when you look at communities in the island and rural areas. Something like 6 out of the 7 firms that they refer to are based in Glasgow. So you can imagine how good that representation is when they do get it. So there's a lack of solicitors. There's lack of access. The means testing is a farce in the context of domestic abuse and is probably a violation of their human rights. So the barriers are not only in quantity and access, but they're in the quality of the design. The system's just not designed appropriately for domestic abuse. We have developed and tested, and the government is now funding a different model, and I hope I'll get an opportunity to talk about that.
Okay, thank you. Sabir, please.
Convener, committee members, legal aid isn't just a service, but for those seeking protection in the UK and here in Scotland, is an important lifeline, and for refugees navigating a very complex, inhumane asylum process, often in a language that is not one that they speak or understand, and a very complex legal language as well that most of us with a good command of English would struggle to get around. Access to quality legal representation can mean the difference between justice and injustice. Today I bring to you evidence not based only on numbers, but real people with hopes and aspirations, looking to be part of our society and have access to everything our society has to offer. SRC, I mean, our position at Scottish Refugee Council is that legal aid assistance should not only be provided to lawyers, but to the wider network of organisations as well, to provide that second-tier support. Because when people arrive, they're not coming from backgrounds or societies where they have established legal frameworks. I mean, for some people, getting to know the complexity of the asylum system will be that first process. People don't know that they have to submit their claim through a lawyer. They're not coming over with a strong knowledge of the UK's asylum system, but also the legal system as well. So I think there's quite a bit of initial preparatory work that needs to be done before somebody engages with a lawyer. I mean, the challenges we face in our work at Scottish Refugee Council are not dissimilar to what colleagues have shared already. But again, I think in terms of access, the focus is very much on the centre build, but I think it's just the access, quality and consistency of legal support to people at the various stages. I think the system also does not take understanding around the trauma-informed approach to people. So people are arriving from conflicts. They are they have experienced a perilous journey, separation from families, and arriving in a strange new world. I think that trauma-informed approach is very, very important, and especially if you then ask somebody with that terrible experience to join a call with a person called a lawyer online or on the phone, it's not making that legal support accessible, but it is re-traumatizing for some people, because it's basically the lawyer's role to ask why this person is submitting a claim for asylum in the UK. So you might have to go through some terrible experiences, but doing that on a call or speaking into a computer, then speaking to a human being who can listen and take your case, and some of the evidence is very, very important. Demand in this area obviously outstrips supply. There are many complex cases of people who have their appeals rights exhausted. Again, they're also priority, and that destitution and poverty within that group continues, because unless you submit a fresh claim or there is a lawyer available who can take a fresh claim, then you continue to live in that destitution whilst you're trying to rebuild your life. So it's that concept of moving people from war into poverty and longer-term destitution. There's delays in finding a lawyer as well. I mean, there are people who would be on a helpline at Scottish Refugee Council, and even people approaching me as the Chief Executive of Scottish Refugee Council and saying, I'm waiting for a lawyer to speak with me about a family reunion application right in Glasgow for 2 months. So this is not a matter of just somebody waiting outside of the Central Belt to speak to a lawyer, but even within the Central Belt as well, that there is that pressure on demand. Language continues to be a barrier. I think some of the letters relating to asylum claims are very, very complex to understand, even for lawyers. But if you get one of those through the post or email, and not having access to a lawyer immediately to understand what is the immediate deadline for you to then submit fresh evidence or other evidence, sometimes people do miss important deadlines because of availability of lawyers. And I think the other important point that I can elaborate on later is the importance of representation before people submit their substantive interview. That evidence is very, very important. I think given the UK's speeded up asylum process as well now, some people miss out on providing vital evidence to go with their claim before their substantive interview, and then that interview happens, they haven't provided the evidence to strengthen their claim for asylum, and most people get refused. And then that puts additional pressure on the system, because then they have to submit fresh claims with additional evidence. I think that creates additional pressures on the system, but also on the individuals as well, because ultimately these are people who are simply looking to rebuild their lives, be part of our society and start contributing, but sadly the legal system is putting them at that disadvantage. Thank you.
Thank you. Thank you very much for that. I'm just going to note very politely that we're almost halfway through our session and we've only had one question asked. So if we could please be as succinct as possible. But I do recognise this is a very important subject and you do have a lot that you would like to say. Just on that, we heard that rurality has an impact, an additional barrier on access to justice. Would anyone like to come in and discuss that? Kevin?
Yeah, I'll keep it succinct. We've been using the phrase legal aid deserts since the Evans Review in 2018. This was in relation to availability issues of solicitors in the Highlands and also in Aberdeenshire. We made the point at the time that the private structure of the profession has meant that the aspiration of legal aid in every part of the country was becoming unachievable. we were aware of cases, and it follows, mirrors what Marcia said about the Highlands and Islands. One case in particular where there literally was a race between separated parents to get in touch with the one and only solicitor. Some of this was masked during COVID-19 with the introduction of online cases, so some of the Central Belt firms could pick up some of the slack. However, the return to what's been called normality has been brutal for the people that we support. So we see that what was a question about rurality is now permeating the whole system, and so that transformative legislative rule changes in the short term, it needs to happen soon.
Thank you. Marcia, please.
Just to add as quickly as I can, a good example is, and we hear from managers across the peace in rural and island communities all the time about this problem, is exactly that. And in the context of domestic abuse, if a firm is representing the accused, then they can't take the woman's case. And it is exactly that, a race, and to that one solicitor, and many of the solicitors will take, as I said, parts of a case, but not all of the legal needs that a woman has. And then by the time she winds up with a solicitor, it's usually some time later, and it's somebody. I heard this from somebody in Shetland last year about clearly the lawyer had taken so many cases, was based in Glasgow, had taken so many cases remotely that was mixing up his clients and talking about somebody else's experiences in a court when it's actually not his client. I mean, it is a desert, but it's more than that. I mean, it's a desert all over Scotland in a lot of places, but the folks are dying of thirst up in the more rural areas.
Sabir.
Yeah, convener, as I said, I'll be bringing case studies and anecdotes of people that are in touch with us. So in terms of representation and lack of representation, we are working with someone who is living in an asylum hotel and is also age disputed. So I think it's that complexity of the nature of some of these cases as well. So it's not just your asylum claim, it's that age dispute, the additional dimension that brings. When he was referred to Scottish Refugee Council 2 months after arrival, he was not linked to a solicitor because he was not aware that a solicitor could help him challenge his case and also help with representation for his asylum claim. So he was due to attend a substantive interview, that important point, without any preparation from the solicitor, which meant that he was less prepared to answer any questions and did not know what to expect. So in a sense, that kind of case could, if it goes through the speed-up process, could end up being an additional burden on the legal aid system, because the case potentially could be refused, and then the need for a fresh claim, and then so I think that upstream intervention and early investment is very, very important. I think that makes that case for investment in the sector beyond the legal sector as well, because that preparatory work is as important as the stages later on.
Thank you. We now have a supplementary on this from Tess White, please.
Thank you. Dr. Scott, you talk about the model, so maybe this is the opportunity if you could share that with us, through a rural and remote lens initially. Thank you.
Ooh, this is hard to be quick, so I'll do my best. So, as I said, we've known that this was a problem for a long time, and I have to say, from a fair amount of support from officials in the justice area in the Scottish government, who were also concerned that the model wasn't fit for purpose. But there was clearly no evidence that things were going to change or change quickly for sure. So we talked to Martin Evans, who had just finished the independent review, about his recommendation about funding advice agencies like ourselves and Scottish Refugee Council, or removing the legal barriers for us to provide legal services directly. Those barriers are still in place, but there is legislation, I believe, that's now being, the regulations are being rewritten. So that will be easier, which is a good change. But Martin put me in touch with the Legal Education Foundation. We got a grant, long cutting a lot of history there, got a grant to trial a model. And this was in COVID, so you can imagine the complexities of that, to trial a model in Edinburgh Women's Aid that hosted a family lawyer in what is essentially a victim support organization, so in Edinburgh Women's Aid. And our test of that model was intended to demonstrate, and did in the evaluation, a number of things. One was that an early intervention reduces court burden, also reduces trauma, reduces the need for services from legal aid. It was also cheaper. So, and we have qualitative and quantitative evidence that demonstrated that in the first year of the pilot. The Legal Education Foundation paid for that. The Scottish Government was convinced, and they came through, and they have been funding the project ever since, although unremittent difficulties with the bureaucracy of SLAB, and that's another question you're welcome to ask. So we then went to Legal Education Foundation, and with their support have gotten money to trial the model in Shetland and Orkney, because I'm not convinced that designing a model based on the central belt default that's in Edinburgh is going to be fit for purpose for island communities and rural communities, which are probably need different designs. Anyway, so we did an evidence gathering session, excuse me, funded by LEF, Legal Education Foundation, and then we designed a pilot. And we got the money to run it for a year, and we can't find a solicitor. We pay a good salary, it's competitive, but because it's a one-year post, it's not secure. And lots of lawyers are really interested. So clearly the system is so resistant to change that we can't even attract a solicitor for this program in which their salary is guaranteed. But the model, as I said, reduces trauma, is an early intervention, reduces court burden, and is cheaper.
Thank you. And a follow-up question is, looking at figures relating to women trying to access legal aid in rural areas following domestic abuse, do you have any data on the number?
SLAB will have got some data, and certainly we have some data from our groups. Multiple years we've gathered that data, and I think that probably the most up-to-date data is from the referral assistance program that SLAB, working with us, set up. So it's a organizations around Scotland can call in, women's aid organizations, and refer a woman to them. And they have an annual report that says how many women were referred, how many women actually got a solicitor, and
roughly.
Oh, I don't know what the total numbers are. And also, I think that, do not mistake that that those numbers represent the unmet need, because we can't. It's difficult even to get people to believe that SLAB will find them a solicitor anymore. So it's hard to get people to refer, or if they've been knocked back because, oh my God, they make £200 a week, then they're never going to ask again. So I do think that that data is not available in terms of what the unmet need is.
I think, and as well, that's something our committee can actually try and pull some data from somewhere. Just a final question on this section of remote and rural. You touched upon this, the thirst that's not quenched in the desert, and the race in remote and rural areas for a solicitor. So the abuser is, and if I understood it correctly, the abuser is often first to get the solicitor. So any other challenges around that? Is you talk about the number of solicitors coming to the position, and is that the only way to solve this huge issue?
Yeah, I mean, it is difficult. If you can imagine, so the abuser has probably one or two tasks to manage, right? Been convicted or not convicted, so has to manage the legal situation. And the woman, usually with children, has to manage possibly being made homeless, having uprooted her children, not then having the money coming in from the other source of income, if he was one. So it's really not too surprising that she might not be the first one at the door of the solicitors. But even so, they shouldn't have to race with each other. But the other problem is that in really rural areas, as you may well know, the sheriffs and the solicitors and the local system drivers all know each other, and the difficulty for women to feel like this is an environment in which they'll get a fair hearing is sometimes difficult, which is why a solicitor based in a victims organization where they'll get the support around them. The lawyer doesn't have to provide that support because it's there in the system, and it would be, for instance, in your organization, the lawyer just has to provide legal support, and it makes a huge difference to the quality of the outcome.
Thank you. Thank you.
Questions from Pam Gossel, please.
Thank you, Convener. Good morning, panel, and thank you for the information you've provided so far. We recently became aware of the case of a woman who was turned down not by one, not by two, but shockingly 116 law firms who would not take up her divorce case. As you know, it takes a lot for a survivor, especially a woman, to come forward, let alone to seek legal aid. This is a woman who was assaulted by her husband, and having to find legal aid and then to be turned down adds extra layers of stress. And this isn't the only case. Last week, we heard evidence from Just Right, who said that people sometimes contact 30 to 50 law firms before the case can get picked up. Scottish Women's Aid have said that survivors of abuse in some areas are faced with challenge of local solicitors representing the abuser, leaving them to have to find a solicitor in another part of the country, making things even more complicated. I've spoken to many survivors of domestic abuse through my Prevention of Domestic Abuse Scotland bill, and all I can say is that many of these women are extremely vulnerable. Therefore, what should be done to make their lives a little bit easier? I know, Dr Marsha, you've already mentioned in some of the questions you've answered that the fact that, you know, it's not just access is the problem, resources are the problem, but also the fact that the model isn't fit. So it would be really good to hear from you what more can be done. And I know you've covered some of this.
I think a lot of the evidence provided last week probably is the same that I would say, which is there are some quick fixes. The eligibility requirements, and I probably won't use the right words, but not only the means test, but what's the other test? Merit test, thank you. I knew there was a lawyer to my left, thank you for that. You know, it's all designed to keep people out rather than to get the folks in who have access to justice need. And those are things that don't require primary legislation to change. And that would make a huge difference, I think. I think making the system friendlier for lawyers, and I absolutely have no appetite for getting involved in the controversy over legal aid prices, but I do know that the system is cumbersome for everybody. So I think that there lots of changes that could be made to the way the current system is administered that would have quick wins for women and children experiencing domestic abuse. And I do think, as we have said repeatedly, that when domestic abuse is involved, services should be free, and they should be the schedule of covered things should cover what women need rather than so at the moment, for instance, a woman I heard about this yesterday, so she'll be offered a solicitor, but the solicitor will maybe will help her in her child contact civil proceeding, maybe not, but won't help her in the division of the marital estate or in her housing and tenancy legal problems, or in a whole host of things. And all of those things, are the things that are traumatizing her over and over. So there's a whole system change there, and it would be relatively straightforward and quick to do, I think. It won't fix the problem from our perspective for the long term in terms of the fact that when women do get a legal aid service, it is usually provided by somebody who sees them for half an hour, and it's clear from our service that the first interview is 2 hours. Do you know what I mean? In order to debrief a woman and to help get the best evidence in a case. The biggest reason that women call our helpline around legal services, and this is also true for the Scottish Women's Rights Centre's helpline, is for help in civil processes around child contact. Those are directly related in Scotland to the gap between civil and criminal cases. And there is I'm not going to call it a quick fix because even I don't believe that it is, but there is a mechanism, and it's used in lots of other jurisdictions, called an integrated court that brings together so that the same sheriff hears the civil proceedings that has heard the criminal case. And I know that doesn't seem related to legal aid, but actually it will really reduce a woman's need for an additional solicitor to help her, because the sheriff will have heard all the details of the abuse, and will greatly, I think, improve the decision-making and the evidence in civil cases. So I think that there are a number of short-term fixes that will provide more access to a flawed service. And there are another number of things that are probably medium term that could be done that are really important to start now.
No, thank you, Dr. Marshall. I've just one more question to that. You said earlier on that the model of legal aid in Scotland is not fit and it's not demand-led for women and children. Now, earlier on we heard from Fiona that she spoke about the system in England that is not means tested. So is that something you think that we should be having here, especially in domestic abuse cases and many other cases as well?
Absolutely. I mean, I think the reference was in housing, because I know housing, if you're experiencing domestic abuse in England, you got nothing. But in terms, exactly. I mean, how is it demand led? If and how does it follow Scottish policy in every other area of domestic abuse if you're means testing people who are subject to financial and economic abuse?
And especially when at times the partner holds all the financial records and all the finance, and especially when it comes to women, that they don't hold a lot of the information, and then they have to be means tested.
If she wasn't destitute going in, she will be by the time she comes out.
Thank you very much. Is there anybody else that wants to add anything to that?
Oh, don't let me that.
Yeah, I just wanted to say that, the system needs to treat people as people, and families as families that will have breakdowns, people who will live together or have challenges. I think, bearing that in mind as well, because it's not always at the beginning of submitting your asylum claim, it's later on as well. So we work with families that are resettled and don't have to submit an asylum claim, but still later on in various stages, either because of family breakdown or children ending up in care, there are those fearful moments. There was a mother we were working with. Again, she had fear of authority. Speaking with a lawyer was not a solution for her. She thought that will further exacerbate things. And so that, again, that kind of awareness raising that the legal system is here to help and support you, and that it's not only there for a male member of the family, who majority cases from a cultural perspective is the men who will be out there speaking, learning the language, learning about the system, and then the women will only hit the system when things go wrong within the family. And I think, yeah, there needs to be that kind of like speeded up process for complex cases, whether that is family breakdown, children ending up in care, or other complex cases. I think there needs to be a review of all of the barriers in accessing legal aid, and I think that kind of like holistic approach in a sense. So those are compelling cases if somebody has to call for a lawyer for hundreds of times and not get one. And there will be other barriers as well. And I think if there was a review and reform, that should take into account all the barriers that people face at various stages of the need for legal aid.
Sabir, I want to ask you one more question about the cultural side, because, if it's okay, convener, because this came up last week that we spoke about. Now, you spoke about language barriers earlier on, and many of, especially women, when it comes to domestic abuse and housing, are left really in kind of no man's land when it comes down to that. The fact that, you know, they don't have access to the information, but also they can't communicate. You said earlier on, sometimes it's hard to even read the solicitor's letters and interpret that. Do you think that not just language barriers, but cultural as well? And we found last week that the evidence that we took, that in relation to cultural barriers, that sometimes, well, in fact, most of the time, solicitors don't have the time and resources to understand people's background and cultural aspects. Because I certainly know when you come from different backgrounds, it's sometimes you're dealing with a whole family and then a whole community sometimes, not just with that woman or that person that's been domestically abused. So what would you say about that and the cultural stuff, the fact that legal aid doesn't have that training, they don't have those resources, that access to that service?
I think it's just that platform for learning between the legal sector and the third sector as well, because that unique learning needs to be captured in a sense. I think the creation of a platform for immigration and asylum lawyers, as well as those of us in the third sector, I think the cultural point is very, very important, because in various cultures, I mean, speaking to a woman to speak to a lawyer against her husband, is that, yeah, good in terms of family values and others. I think it's all those kind of barriers that are then created where the person may not engage with the legal system to have access to their rights for a variety of reasons, guilt trips, others, and so on. And I think there is a role for those of us in the third sector, in the refugee sector, where there needs to be availability of some resources to our organisations where we could play a bit of a part in that second-tier advice to people. Is bringing the people closer to their rights in a way. So our legal aid is available to everyone. Our other services are equally available to everyone. But sadly, because of various barriers, including language, fear of authority, cultural issues, some in a very complex and vulnerable situation may not be able to access those. And how can we all work together to remove those barriers? And I think, yeah, that role for the third sector to work closely with the legal sector, and not, people don't just need a lawyer, they need protection and that support and safety to come out of a complex situation, whether that's their asylum claim, whether that is appeals rights exhausted, or whether a very complex issue of family breakdown as well.
Can I just add very quickly? I've been remiss in just sort of speaking generally, but absolutely the most marginalized women, whether it's because of race, ethnicity, disability, rurality, are the ones who are absolutely thrown away by the current system. You have to be a good victim You have to be good at getting to your lawyer first. You have to be, getting to the solicitor's office first. You have to be good at representing yourself. You have to speak English. You have to be, all of the things that make a good victim. And then you are still going to struggle to find a service.
Thank you very much. Thank you, Convener.
Okay, thank you. Tess White, please.
Thank you. The question's been asked.
Okay, thank you. Marie McNair, please.
Thank you, Convener, and good morning, panel. The Scottish Government have made several reform proposals in the recent discussion paper on legal aid. One of these was obviously to test different models of delivery, and some of you have already touched on the models already, but it was just really to ask if you had anything else you want to input. Fiona, obviously you spoke about grant funding, so I would be interested to hear what you've got to say on that, if you don't mind.
Yeah, as the recipient of grant funding when I was at Shelter Scotland, a key role is played, and I made reference to a scheme in England, which is the in-court advice. The grant funding model in Scotland goes some way to meeting that ambition, but falls far short. So I would encourage a review of grant funding, which is a part of legal aid expenditure, which has decreased. Okay, so I think if this committee is to look and make recommendations in respect of grant funding, it is to encourage government to increase the amount of money there, because those are the programmes, and we've heard about them, which enable collaboration between third sector legal profession and go some way to meeting unmet legal need. But grant funding needs to be beyond the 12-month term. I can't stress that enough. If we wish to be bold, if we wish to make a dent and bring into the profession a new generation of legal aid lawyers, we need to start looking at 3 to 5 year grants, as well as increasing expenditure. Let's also revisit the scope. Grant funding in the context of housing, with the project I managed, was restricted to rent arrears, and there was an element of so I think we can be much more ambitious. Thankfully, there are some positive reforms mentioned in that paper, as is mentioned. There are other reforms, and I just wish to, in the very short time I have, stress that there are some quick fixes or small tweaks that can be made within that short timescale that have been provided not by just one or two respondents to this inquiry, but several. Advice and assistance eligibility limits. We've reached the stage that those must be reviewed upwards if we're talking about access to justice in Scotland. There's been a call for exempting certain categories of cases from means testing. And the current system, in the context of adults without incapacity, there is no means testing. Let's revisit that for other areas. In the context of a housing emergency, I say there should be no means testing if you're at risk of losing your house or if you're at risk of being turned away from local authority areas. I have acted for women fleeing domestic abuse who've been told there is no accommodation available, and but for the involvement of a solicitor, that woman would have had to return to that abusive household or go somewhere else. Similarly with refugees, there's a huge overlap, and colleagues have spoken very well about the need for a trauma-informed approach. That is not funded in the current rates that legal aid pays. So I think we need to look at the reforms on the table in terms of advice and assistance, exemption, grant funding, and urge for the increase in expenditure of grant funding and a 3 to 5 year commitment. I'll leave it there, and I'm conscious I may not have fully answered your question.
No, thanks, Kevin.
Thank you. That summarises, I think, a lot around Judicare grant funding and all those possibilities. Our response on the broader question of access to justice and how to improve the system would be to support a flexible system. That's the first thing. The bigger visioning gold standard piece for us is where SLAB and other organisations could be referring people to alternatives to court. There's examples of that happening in pilots in England, and there's jurisdictions around the world that do this already, and that would prioritise relationship building, supporting children to see and get the best of both their parents where there's no risk to doing so. And we believe that that would create opportunity for partners like us and the wider legal aid workforce to promote the holistic support that everybody's been driving at in their submissions today. It's one of the biggest issues that we have is we have in family court settings, sometimes disagreeable parents in an emotional space, the court will decide in the interests of the child, but often that child is forgotten. And those same two sometimes disagreeable parents are bound up with other parents where the struggle is real, where there is issues of domestic abuse. That's problematic. And we believe if there was a bit of flexibility in the system, either SLAB could adjust their set-up to allow that function to happen in advance of any legislation, but certainly during the legislative process, we would want to involve our users in that so that we can create that holistic future that we all want to see. The legislation is a winner-takes-all attitude to parenting, and it's stuck in the 70s and 80s, and we can do better.
But like it was mentioned last week with the witnesses there as well. Oh, no problem.
Just really quickly, I do have to say that we need to be very, very cautious about alternative dispute resolution, because we know women every day are being pressured to go into mediation in the context of domestic abuse. Saves the system money, and it's very dangerous. However, putting that's a whole nother hearing aside. In terms of the grant funding, also, in a way, it is a bit of a quick fix compared to others, in the sense that the money can be made the decision can be made in the government relatively quickly. The difficulty that we've seen, so women in Edinburgh had to go without a service for a year because the system moved so slowly. There had been an approval by a minister internally, but the bureaucracy in SLAB is, even for the people in SLAB, I have sympathy. And there's got to be some mechanism for cutting through a lot of that. But also there needs to be a much longer term plan. So funding something for a year means that the day after you fund that, you need to start planning for the next year. And so we had a year's funding in Edinburgh, then there was a year's hiatus where women got no service, and then there was funding for 2 years, which we were thrilled with. But we're approaching the end of that 2-year funds, and there's been no guarantee now of extension, and we're desperately worried that the same scenario is going to repeat. So there needs to be a commitment to this as a problem-solving approach, but also as a stopgap in terms of on the way to system reform, which I think officials are really committed to. And there's got to be a way to streamline the system to make it actually work for the user, not rather than for the folks who are administering it. And you know that there's a whole set of things could then be done to make that smoother.
Very much agree with your comments there, Sabir.
Yeah, thank you. I think we need to bear in mind the context and the shifting landscape of asylum and refugees in Scotland as well. So we now have 30 out of 32 Scottish local authorities with either asylum or refugee resettlement. So the need for that cross-Scotland good quality standard legal advice is now increased, and I think that needs to be taken into account. So previously Glasgow used to be the asylum dispersal city, and that's why there was a strong focus there. But what we need to learn from Glasgow's example. The infrastructure in Glasgow has been developed over the last 20-odd years, and I think that infrastructure of good quality, consistent, accessible legal advice needs to be built right across Scotland, and that needs longer-term commitment from everyone. I think, again, alluding to what colleagues said, there needs to be that increase in legal aid fee for lawyers, so that is also an attractive area for them. Funding, again, longer-term funding, because those of us in the third sector, if we set up, let's say, a legal project, there needs to be a bit of a vision and future for that, for us to then see the impact of that legal project. I think, as I said earlier as well, the need for that platform for better understanding of the system earlier on for people as they arrive, but also an opportunity for the third sector and the legal sector to work together. Review of the barriers too. I think there needs to be a review of all the barriers at all levels. And I think, finally, I'd say, we urge the Scottish Government to deliver on its commitment to introduce a legal aid reform bill. And I think this would be a unique opportunity to shape that by meaningful and consultation with service users, people who access legal aid, but also lawyers and third sector organisations as well. So, we'll leave it at that. Thank you.
Thank you. Thank you, Kevin.
Okay, thank you. We're just coming to the end of our session now. I just want to ask members if they're satisfied that they've asked everything that they would like to ask. They are. Just from me, finally, are there any other issues that you haven't been asked that you would like to raise before we close? Marcia.
Just very quickly, considering this is the Equality and Human Rights and Civil Justice Committee, I think it's worth pointing out that the United Nations Human Rights Committee pointed out in its review of services or review of state parties provision under the human rights violations that the UK as the state party, and they referred specifically to Scotland and Northern Ireland here also, have, and I quote here, that the committee is concerned about the depletion of legal aid lawyers in the state party, including in Northern Ireland and Scotland. Committee also concerned with the legal aid sent, blah, 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 that's England. I think when the problem is so obvious that even the UN, which is pretty clueless about devolution, points out that in Scotland there's a problem, and has in multiple findings across ISESCR, across the Human Rights Committee's reviews, and a number of other mechanisms. It really is past time for the Scottish Government and the Scottish Parliament to act.
Thank you, Kevin.
I've just come in on the point about the UN, which I'll pick up in just a second, but as quick as I can. We find ourselves in a curious position that we're helping individuals understand and make the best of the current adversarial system, but we think it's fallen behind the realities of parenting in Scotland and the makeup of families. The public expects that public services will be funded, responsive, user-led, accountable, and that we meet the challenges of 2025. UNCRC has been incorporated into Scots law. That's a fantastic shift towards a rights-respecting family law system, and it gives us an opportunity then, now it's in law, to think carefully about what we mean by the best interests of the child, how we communicate with them, when we communicate with them, who communicates with them in a contact and dispute situation. There's an Article 9 right to both parents. So legal aid is part of it, but it's not all of it. So thanks for creating that segue there, Marcia. Thank you.
Thank you. Fiona, you have to come in.
Very briefly, because we haven't really touched on retention and recruitment of legal aid lawyers. Now at university I'm working with students, and there is an appetite for students to go into areas of social welfare law. And I think the Scottish Legal Aid Board in their response downplay the impact that legal aid has on that. There are no doubt issues across the profession with retention and recruitment, but where the advice and assistance rate is £63.88 per hour, or grant funding is on a one-year cycle, and the system, and this hasn't been touched on this week, but was made by colleagues last week, that the system is one that does not trust the profession. Solicitors in legal aid practice spend a great deal of time justifying every step in the process, notwithstanding the urgency of the matter or the vulnerability of the client. And those three factors make it very difficult to encourage a new generation of legal aid lawyers to come into the fold, despite the need or the demand there is in the context of housing. It's a hugely interesting area and rewarding area of work, and I want there to be a future generation of housing lawyers assisting, but there will need to be legal aid reform in the imminent future. Thank you.
Okay, thank you. Sabir.
Yeah, just briefly, an issue I wanted to bring to the attention of the committee is the gap in legal aid provision when people are forced to leave Scotland. Again, with the UK government's commitment to processing hubs outside the UK, people might face a situation where they're detained and taken to England to be deported from the UK. Last year, we had a case where somebody was detained in a centre in England, and they couldn't access their lawyer in Scotland because they were no longer here. Solicitors often are keen to continue to represent their clients, but the lack of continuity in the systems prevents that. And I think that could be an issue in the future as well, where people are facing the grim prospects of deportation, but then their lawyers are here. And could they practice and defend their rights whilst then moved into a different legal system in England?
Okay, thank you. Thank you. That brings our first panel to a close. We will suspend briefly while we change over witnesses. Thank you.
Thank you.
Welcome back to the committee. We would now like to welcome our second panel today. We have Professor Katie Boyle, Chair of Human Rights Law and Social Justice, School of Law, University of Strathclyde, Dr Ben Kreisman, Legal Director, Environmental Rights Centre for Scotland. Thank you for attending today. You're very welcome. We're just going to go straight into questions, and I'm going to kick us off by asking, can you explain the accessible, affordable, timely, effective framework and the role access to justice plays in supporting action on human rights breaches? And I'll come to you first, Katie.
Thank you so much, and thank you very much for the invitation to join you today. So I'll speak about the right to have effective remedy, which is the framework that you just mentioned. And it'll be on the basis of previous research I've done. So me and a team of other researchers were funded by the Nuffield Foundation, which funds competitively funded independent academic research, to look at access to justice for social rights across the UK. So we looked at all of the different jurisdictions. We have a sense of how Scotland fares in comparison to other jurisdictions. Now, we used the International Human Rights Framework to help guide us in that, and we used the right to an effective remedy as the standard that we were assessing compliance with, which includes that access to justice should be accessible, affordable, timely and effective. But really interestingly, when you start to unpack that framework, all of those terms mean different things to different people. And so we have a lot of helpful commentary on what an effective remedy is. We have UN guidance on that, but we also undertook empirical research with practitioners across all advice tiers, from food bank advice to solicitors, to advocates, to barristers, to try and understand how they understood it. And very interestingly, the legal profession often thinks of effective remedies as about equal access to effective processes. So they think of it as a remedy being judicial review or access to a tribunal, or, for example, having something determined by the Scottish Public Services Ombudsman. But actually, people themselves and the UN framework and international law says not only do you need equal access to these processes that are accessible, timely and affordable, but the remedies, as in terms of the outcome, has to be effective. So whatever route to remedy you take, it must result in justice being delivered. Now, that doesn't mean that everybody needs to win all cases, but the actual route that you use needs to have the ability to deliver justice. And what's very problematic with our civil justice system across the UK is we haven't calibrated it in a way that delivers accessible, timely, affordable or effective processes or outcomes. And there are many different reasons for that, some of which are just about historical background. But ultimately, what legal aid does and what civil legal aid does is play an absolutely crucial cog in a much bigger wheel, which is a whole access to justice, civil justice system. And so it should be understood as part of a broader framework. It's like a complex jigsaw, and all different bodies need to be in to put their part in order to make the system work. And at the moment, the civil legal aid system is not operating in order to help deliver on that, and in particular to deliver the outcomes that are needed. And this is just cross-cutting across social rights issues. So I focus specifically on fuel, housing, social security, an adequate standard of living and housing. So we basically saw across all of these areas that justice is not delivered for people. And there's two really important reasons why that happens. One is, if you think about it from the perspective of somebody's life, these issues are interconnected, but our justice system fragments them into separate issues. So they all have separate routes to remedy. And the second issue is they're often systemic in nature. And that means that they apply to many people at the same time. So if you have a social security issue problem, then it applies to many people. Same with housing, damp and mould, habitability, evictions. It's normally systemic in nature, and the legal aid system doesn't deliver clustered justice funding, and it doesn't deliver systemic and structural funding, which is what's expected of an effective remedy in international law.
Thank you. Ben, please.
Thank you, Convener, and good morning to the committee. Thanks for the opportunity to give evidence today and for investigating this important topic. I think this question, I don't have a huge amount to provide on this question, but just in terms of the question about the role that access to justice plays in challenging human rights breaches. In terms of my organisation's work, we focus on the right to a healthy environment. In international law terms, it's kind of well recognised that there's a human right to live in a clean and healthy environment, and that the enjoyment of that right underpins the enjoyment of most other human rights. Breaches of that right, the right to a healthy environment, are often they often come about as a result of breaches of environmental laws, and in the absence of access to justice, it's very difficult to challenge breaches of environmental laws. So that's really the importance of access to justice in challenging human rights breaches in the context of my organisation.
Thank you. Now move on to questions from Tess White, please.
Thank you, Convener. Professor Boyle, I found it really interesting when you talked about the two issues being fragmentation and systemic. If I can take an example, so we're increasingly seeing groups like For Women Scotland use crowdfunding to fund challenges to the Scottish Government's interpretation and implementation of the law. Crowdfunding is becoming a powerful tool to shape change, but it's not always an option for individuals, community groups and other organisations. So my question is, what role does civil legal assistance play in supporting access to justice in situations like this? And could it have an expanded role?
Absolutely, thank you. So I think your question relates to the operation of Regulation 15. So Regulation 15 of the 2002 regulations makes it very difficult to raise public interest litigation using legal aid. And part of the reason for that is that Regulation 15 performs, I'm sure, a very important historic role about trying to manage the types of cases that can come before court, and also trying to stem the flow of what may be deemed as vexatious claims or a sort of litigation type culture. However, Regulation 15 and the way it operates also needs to be balanced with an understanding of more current research, which tells us that often the issues which legal aid ought to support, which is covering people who are experiencing socioeconomic deprivation, like that's our main demographic for legal aid. We can use legal aid in ways that allow public interest litigation or that facilitate group proceedings when it's not clear to the Scottish Legal Aid Board whether or not someone else could effectively have paid for that case. So there's several problems around Regulation 15. Firstly, the wording of it isn't entirely clear, so I think that in itself will have a chilling effect. Perhaps what would be said in response to Regulation 15 having a chilling effect on public interest and group proceedings is that perhaps there's not many applications for it. But if you were a solicitor working in this area and looked at the regulation, you might say, well, that's probably not going to fly in terms of what we're looking at here. This is not a unique problem to Scotland. The problem in relying on funding public interest cases through, for example, the group funding, is you will have an uneven distribution of issues that come before the court. It is for the court and Parliament and the government to regulate what types of cases come before it, and they do that using standing. So if there is standing, if someone can, I mean, we've had post-AXA in Scotland, we've had broader standing to bring cases. The UNCRC specifically makes it clear, the UNCRC Incorporation Act, that there should be wider tests. And the reason why we have public interest litigation and group proceedings is to try and relieve the burden on the individual. So we spoke to practitioners across the UK, and one of the things they consistently told us across all the areas relating to poverty, people not being able to feed their children, not being able to heat their homes having mould and damp, issues about in-work poverty, social security benefits not helping them address the cost of living crisis. Ultimately, these issues are all systemic in nature, but we don't see those types of cases. And we know that we need to have a more collective response to them. So regulation sort of performs this role of preventing civil legal aid stepping in to that collective response. There must be a better way to try and balance that. And I know SLAB, and I understand the Scottish Government has in the past, before yourselves, given evidence to that effect that it's not working in practice. But any economic, social, cultural or environmental issues will be systemic in nature by virtue of the fact they tend to apply to lots of people. And Regulation 15 prevents us addressing public interest litigation via legal aid and group proceedings via legal aid. But also SLAB have what's called a reasonableness test about the merits of a case. So there's room, first of all, to clarify the wording of Regulation 15 and try and make it strike a better balance about cases being needed in relation to either group proceedings or public interest litigation, which are about the issue itself rather than the person, so not always tying legal aid to an individual. Firstly, to prevent that individual taking on the burden for everybody else, which is just a completely unfair expectation to place on someone. But also sometimes it won't always be clear that only one person is impacted because it's a collective issue, and so we need clarity around that. And then second, SLAB could have improved their guidance on the reasonableness test, which is about the merits of the case, to say, look, if this is going to address a wider public interest point, and it's going to affect many people if we fund this particular case, then the practical benefits of that and for society are worth funding it. And you have changes to the rules in Northern Ireland, which has done that. It's expanded that test, and that doesn't require any legislation. However, I could understand why SLAB would be concerned about taking that step until Regulation 15 is actually clarified, and that's really, really important that happens.
Good, thank you. Back to you, Convener.
Thank you. Evelyn Tweed, please.
Thanks, Convener. And just to follow on from that, what would be the benefits of group actions? What would that bring us?
So in terms of group actions, what the research tells us is that if you place, so you can have basically three ways of addressing an issue which is of wide public importance. The first is the one that we've typically used, which you have one individual that raises it on behalf of everyone else. And then you test that case and you sift all other cases, and that's the way it's operated in Scotland historically. But the court itself realised that that was problematic because you will have different issues that arise in all those different separate individuals, and really the court should look at it as a whole. So they changed what is called Rule 2.2 of court procedures in order to enable multi-group actions. Then the Parliament said, well, actually, we need to clarify this on a wider scale. We can't just rely on the court doing this on an ad hoc basis. So we had the Group Proceedings Act of 2018, and then we had rules that followed in 2020 to help with a Group Proceeding Act. And they are both, the motivation behind that is to try and remove the burden on the individual, because the resilience it takes for one person to fight a case, I mean, ultimately they may be offered something which is a settlement out of court, and for them to say, oh, please don't take that settlement, because actually if we fight this for everybody, we'll get a much better outcome. That is not a fair burden to place on that individual. But they also have to have the not only financial resources, the emotional resources, to actually take the resilience to do that. And then you find these really unusual situations where we're aware of an issue, but legal aid lawyers or law centres, like, for example, the Child Poverty Action Group, is looking for the kind of right person for the case. And so injustice is just unaddressed for however long that takes. So there's many, many reasons why it would be helpful to be able to have group proceedings. I think the problem is, the worry is that you're going to open up to like big financial compensation claims. But from a human rights and equality perspective, in terms of international law, and also in terms of the human rights framework that Scotland was trying to create in relation to the Human Rights Bill and to UNCRC incorporation, is that reparation isn't just about damages. It's not always about financial compensation. That might be an important part of an effective remedy, but actually what we've found from international comparative law is that effective remedies tend to be an aggregate of remedies to actually fix the problem. So people want an apology, they want the violation to stop happening, and they want it to not happen to anyone else. And that maps on to the international framework, which says we need guarantees of non-repetition. So the idea is you fix the problem for everyone, and actually in terms of efficiency, the system improves overall. At the moment, we have these huge feedback loops that are missing. So if you look at, we don't have the data for the first tier tribunal in Scotland, but if you look at the tribunals for social security and immigration and asylum cases, which are in reserved areas of law, we're looking at between 50% of cases being where decisions are unlawful for immigration and asylum cases, and up to 70% in social security decisions unlawful. Like the waste in that system of that many decisions being overturned, if you could have fixed it on a more collective basis. And so it's just, and you see international courts responding to this. The European Court of Human Rights has a pilot system to fix things on a broader scale, to address structural issues, to go back and say, look, could we fix this problem by actually changing the legislation so that the violation stops for everyone, instead of people just waiting in an individual line to raise injustice issues, which are collective in nature. So it's that whole idea of individualising injustice, which is collective in nature, which is the problem. And group proceedings and public interest can help remove that burden on the individual.
So it would be a much more efficient system.
I mean, yeah, absolutely. The efficiencies in the system, we don't actually know to what degree, but I think that's really important research that needs to happen, because what you see in, for example, the Scottish Legal Aid Board, often they're looking at it from an efficiency perspective. But what seems to be missing is an understanding of actually, if you were able to deal with stuff more collectively, you could improve those efficiencies. And rather than having this double audit system in terms of checking that solicitors are paying for things, we could have a system which is focused on trying to address these collective issues that people face. So it's almost like changing the aims and the structure to recalibrate it for a human rights and equality perspective, which at the moment it's not. And that's a known problem for SLAB, because they had a Section 23 regulation enforcement contract with the Equality and Human Rights Commission in 2021 that said we're not happy with your equality and human rights impact. So it's fair to say there's been a learning journey there, and there's been huge increases, for example, in equality impact assessments. But the data that SLAB is currently using is about its current clients, or that I would refer to as human beings with human rights. So the clients that they serve is where they're gathering that data, instead of understanding the broader societal issues. They're not gathering the data to understand why healthy life expectancy has reduced for people in poorer areas. People are dying younger in poorer areas. They have cross-cutting issues, interconnected, clustered problems that aren't being addressed and the justice system can't cope with. That's the data that should be driving a service which is for people from socioeconomically deprived areas. I mean, the Law Society and evidence has explained that out of the 139 most deprived areas in Scotland, 122 of them don't have a civil legal aid firm. So the depth of unmet needs and unmet human rights is really something that can't continue.
Not specifically on this question, but slightly going back to Tess White's question and some of what Professor Boyle said earlier about Regulation 15. Regulation 15 is really, the issues with Regulation 15 are really one of the main points that I'd like to make to the committee today. And I've given evidence to the committee before, back in November, about the barriers that Regulation 15 creates in terms of accessing justice in environmental matters. And probably after today, the committee will be so bored of Regulation 15 that you'll never want to hear it again in your life. But I'm just going to go through it, so please bear with me. It makes it really difficult to obtain legal aid in environmental cases. Regulation 15 sets out the joint interest test, and Professor Boyle has clearly articulated the problems with Regulation 15 in terms of a lack of clarity. So people don't really understand exactly what it means. And I'm not sure that SLAB really understand what it means, which is not particularly effective law to start off with. But there are two elements to Regulation 15. It says that people applying for legal aid can, whose cases involve joint interests, and in environmental cases, they'll almost always involve joint interests because protecting the environment is an inherently public interest issue. In joint interest cases, you can only be granted legal aid if the Legal Aid Board is satisfied that either there's serious prejudice or that it would not be reasonable and proper for the other people who are jointly concerned in the case to pay the expenses that would otherwise be paid from legal aid. So there's kind of two elements to that test. The serious prejudice side of things, the first element, which is Regulation 15A, that sets out a really high bar for applicants to meet. Again, we don't really know what serious prejudice is because it's not defined in the regulations or guidance. But in terms of environmental cases, they often involve diffuse public interests which don't have a severe detrimental impact on any one person. So it's quite difficult to say that any one person is seriously prejudiced in an environmental case. So it's particularly difficult for environmental cases. And then in terms of the second limb of Regulation 15, Regulation 15B, which is about other people chipping in and paying the costs of the case, as well as the lack of clarity in that aspect of the joint interest test, there is also a number of practical difficulties which come from Regulation 15B. So it assumes that somehow you're able to identify the other people who have a joint interest in the case with the person applying for legal aid. That's going to be very difficult to do, particularly if you're talking about a case that involves some national issue or a high-profile local issue. There might be tens or hundreds, possibly thousands of people with an interest in that case. If you're able to identify those people, then obtaining financial information from them is going to be very difficult as well. And if somehow you can get through those first two practical hurdles of identifying people with a joint interest and obtaining financial information from them, then where someone applying for legal aid has identified those other parties with a joint interest who might be able to fund their case, there are probably going to be difficulties in establishing what sort of legal tactics are to be used if they're to club together and pool their resources. And there may be differences such that the person applying for legal aid and the other person with a joint interest just don't want to litigate together, in which case, why should the resources of the other person with a joint interest be taken into account by the Legal Aid Board? So we have a proposal to change that, which is essentially to amend the 2002 regulations in a way that excludes cases within the scope of the Aarhus Convention from Regulation 15. In our written evidence to the committee, we've provided some draft wording that could be used for regulations to amend it in that way. And the Scottish Government has the power to amend those regulations. Their power comes from Section 36 of the Legal Aid Scotland Act 1986. So it's a relatively simple change that could be made, a quick win that could be made just by regulations. It doesn't require primary legislation.
Thank you.
Dr. Christman, can I ask you about that, just to follow up? So you talk about the Aarhus Convention, and I wonder if this case could apply to that. So the committee, as you're aware, recently scrutinised the Aarhus Convention, and I raised considerable barriers for community action groups to oppose new energy transmission infrastructure. And there's a rare equality of arms. There's rarely equality. So there's a huge inequality for groups who want to challenge what they see as environmental vandalism that they're experiencing. And the Environmental Law Centre Scotland was of the view that the Scottish Government was in breach of the Convention. So you've touched upon Regulation 15 of the Civil Legal Aid Scotland regulations and access to justice on environmental issues. And that quick fix that you talk about, could that relate to this?
To resolving problems with the Aarhus Convention? Yes,
where huge environmental vandalism issues, where people feel completely disempowered, it's like a David and Goliath situation, and there's nowhere to go in terms of justice.
It potentially could. So taking your example of someone concerned about energy infrastructure, if we're talking about potentially challenging a decision to grant consent for energy infrastructure, if there was a person concerned by that decision at the moment who wanted to apply for legal aid to challenge that decision, chances are they would be caught by Regulation 15 and they would be unable to obtain legal aid because of Regulation 15. But if the proposal that we're suggesting to amend Regulation 15 in the way that we've suggested was to come into effect, then they might have a chance of obtaining legal aid for that. Yes.
Okay. Thank you. Thank you.
Thank you. I'll now move on to questions from Marie McNair, please.
Thank you, Convener, and good morning, panel. I'll focus my questions on a recent discussion paper on legal aid, where the Scottish Government made a number of reform proposals, one of those being the test of different models of delivery. Do you have any sort of views or advantages or disadvantages of the models, such as grant funding that I touched on in the last session, contracting or using solicitors directly employed by the Scottish Legal Aid Board? And I'll pop it to yourself, Professor Boyle.
Yes, thank you so much. I think there's probably room for more details on how different models might operate, but I think in all the evidence that we've had today and the excellent evidence you had from practitioners themselves last week and today, probably the best thing to do is to work with the people that use the system to help design models that operate efficiently, and things like one-year grants is problematic. Equally, relying only on sort of salaried lawyers that are paid via slab might not address all of the issues around a sufficiency of numbers in terms of solicitors, advice deserts, and those who specialise in different areas. The idea of having a sort of a legal aid funded person seems like a good way of helping to address some of the clustered nature. But again, so really we should be, I mean, there's so much rich evidence about how if you are trying to address these issues and be as preventative as possible, as early on as possible, you can stop things spiralling, because you end up with lots of connected issues. And the research suggests, for example, co-locating services. So there's excellent work by Hazel Genn, Pascal Plazo and others for years, for decades, that have looked at this idea of co-locating services where people use them. So if you even think about the number of different banks we have for poverty banks, like this is all connected to human rights violations, social rights violations, and ultimately should be getting addressed as unmet legal needs. So there could be more to engage with the profession about what would work best, and probably a multi-model version of all different ways. Because if you look at evidence from the Scottish Human Rights Commission, for example, on rural experience. It is different to what kind of human rights needs people have in other settings. So I think there needs to be a broad variety, an aggregate of models, but ideally that trust between the professions lab and government, and the idea of involving people with lived experience, of course, will be of huge benefit because they know more than anyone what's needed to help address the very clustered and interconnected nature of the problems they face.
Thank you, that's really helpful. Dr. Kreisman, do you have anything? It's okay if you don't.
Yes, just a couple of comments on the discussion paper from the Scottish Government. Professor Boyle has very diplomatically said that there was room for more details in that paper around models of delivery. I'll be less diplomatic. I think it was vague, non-committal and wholly unsatisfactory on that point. There was really just some words with absolutely no detail about what they're proposing. And on that paper more generally, while it's positive that there are some reforms to legal aid outlined in that paper, they're very minor and they don't really touch the sides in terms of the general legal aid crisis, which you've heard evidence about. So the committee might want to challenge the ministers a little bit on that paper and why the reforms are so lacklustre and lacking in that paper.
Thank you, I really appreciate your honesty there.
Thank you. And then move on to questions from Pam Gosling, please.
Thank you, Convener. Good morning, panel, and thank you for the information you've provided so far. Last week, I brought up the issue of abusive partners controlling all of the household finances. And in many cases, the abused person, which usually the woman, does not know the household annual income. Therefore, the victim risks being turned down from receiving legal aid, either because the household income is too high or because there is no clear indication as to what the household income is. Survivors of domestic abuse come from all walks of life and all socio-economic backgrounds. Witnesses from last week's session called for removing the criteria needed to access legal aid for certain cases, such as those seeking civil protection orders and survivors of domestic abuse. So what changes do you believe need to happen to ensure a human rights-based approach to resolving legal disputes? And Professor Katie, do you want to go first? Or?
Thank you. Sorry, go ahead.
In terms of domestic abuse cases in particular, I can't provide any evidence on that point, but I can certainly provide evidence on the need for reform of the financial eligibility criteria for legal aid more broadly. My organisation is part of the Scottish Association of Law Centres, SALC, which last year published a paper on the need to reform the financial eligibility thresholds for advice and assistance legal aid. Advice and assistance legal aid, the committee will probably know, is the type of legal aid that pays for solicitors doing work for clients that doesn't involve litigation. So that can involve kind of reviewing documents, assessing whether someone might have a case, phone calls, negotiation, and potentially resolving a case without it having to go to court. The low eligibility thresholds for advice and assistance are a real barrier to access to justice. They are particularly low. To be eligible for advice and assistance, you have to meet both disposable income and disposable capital thresholds. The disposable income threshold is £245 per week, and the disposable capital threshold is £1,716. Those thresholds have remained the same since 2011, so they've been in place for around 14 years. And due to inflation, they've effectively decreased in real terms. To put them into context, the income threshold, which says if you have more than £245 per week in disposable income, that's equivalent to someone who's over 21 years old, in a minimum wage job working 20 hours per week. That's the kind of level of income that we're talking about. The capital threshold is about 1/10 of the equivalent threshold that applies to universal credit. The capital threshold for applying for universal credit is £16,000. And I don't think it's too controversial to say that universal credit is not seen as the most generous of social security payments in the world. That can leave you in a kind of absurd situation where someone who is in receipt of universal credit is ineligible for advice and assistance because they have savings or other capital that's over around £1,700. So they can be eligible for universal credit, but ineligible for advice and assistance. And someone who's receiving universal credit is effectively expected to pay privately for legal advice. And SALC, the paper that was published last year, SALC proposed that the Scottish Government should increase those eligibility thresholds and make them equivalent to the thresholds that apply to civil legal aid. The civil legal aid thresholds are much more generous than advice and assistance, so it's around £26,000 per year in disposable income and around £13,000 in capital. If we increased the thresholds to meet the civil legal aid thresholds, there would be a much larger proportion of the population eligible for advice and assistance. And again, the power to make that change, the Scottish Government has that power. They can make that change by regulations, and it comes from Section 36 of the 1986 Act, which I mentioned earlier. So that's another relatively simple thing that the Scottish Government could do to increase access to justice.
Thank you. Thank you very much. Yes, I think as you've heard from other witnesses about the bureaucracy in the system, not only holds up the delivery of justice in terms of an effective remedy and the timeliness and affordability of it, but it's this, what your question relates to is that broader point about access as well. There's a lot of positive research that tells us when dealing with issues such as the one that you mentioned around the possibility of financial and economic abuse and domestic violence, victims of domestic violence, the case to have automatic enrolment into a scheme that helps support them without a means test if it becomes too problematic, as it would appear from all the witnesses, it is to determine whether or not that person can indeed demonstrate that they would have the funds or not. And then second, as my colleagues already mentioned, the means test itself is woefully too low. I found Andy Cyril's evidence last week really helpful about thinking about the actual cost of what a case is. You know, the idea that someone that's got more than, £1,400 in savings that could then, take a case that costs £500,000 with the potential of having to pay the other side's cost too. I mean, that just doesn't work in practice. But that is not just about the role that the Scottish Legal Aid Board plays, and it comes back to my initial point about this being quite a complex sort of 3D puzzle that needs to be solved and people playing different roles. In terms of what could be done immediately, there was really helpful advice about this idea of being able to open a case and have funding automatically available rather than justifying every single piece of evidence that's required, every phone call, every letter, every meeting. When you look at the quality impact assessments, but prior to the Section 23 agreement that was put in place in 2021, SLAB had roughly around two equality impact assessments per year over a 10-year period. Since 2021, it's had, on average, 16 equality impact assessments per year. So, like I say, there is a learning process there. But those equality impact assessments don't necessarily gather the disaggregated data to understand the cultural dimensions, dimensions for different ethnic groups, the dimensions for people with different needs in terms of disability. It's basically not disaggregated, right? And in a sense, what we see is there's guidance in there to say, look, if this person needs a trauma-informed approach, you might give them more, we'll give them more time for that meeting, for example. But yet what we're hearing from practitioners is the double audit is not operating that way because they're going through this process of abatement where they're arguing about the nitty-gritty of small calls and how much time is needed. But ultimately what it comes down to is because that system and the bureaucracy is so difficult to actually make businesses work in practice, we don't have the professional expertise, the breadth of expertise. We don't have enough solicitors to do that, and we don't even understand the depth of that. So we can see, for example, in relation to Fiona's evidence earlier about evictions and talking about 99% represented, 9% not. In 2022 to 2023, there were 3,945 eviction cases before the Sheriff Court. And when you look at SLAB cases supported, 173 received legal aid for eviction. So when you look at the actual way things are playing out in practice, some areas are well covered and SLAB can break down in terms of what's happening. But those that group that you mentioned, they will be facing all of those cross-cutting issues. They need somewhere safe to live. They need to be able to give their children food to eat. They need to be able to heat their home. It's everyday needs, and these are clustered and interconnected. And we just don't have the breadth of expertise to deal with all those areas. So legal aid needs massive investment as a field of practice. SLAB can do some of that work to make it more viable. But ultimately, we have to have a curriculum, a law curriculum. The Law Society doesn't have social welfare or environmental human rights or equality as compulsory subjects to qualify as a solicitor. They're sort of covered under other things, but they're not specialist subjects that we require law students to learn. If you want to qualify as a solicitor, you have to play for a diploma in practice. If you go into private practice often pays that for you. Legal aid firms can't afford to pay for students to do diplomas. So we have basically this whole complex puzzle and different things people could do, but we need to increase our breadth of knowledge, our expertise, and then make it viable for people to actually practice in those areas, to start to address that. And just to say, in terms of what practitioners tell us, they are in constant crisis mode. It's just constant. The people they work with are in constant crisis mode. They have to think, can I even get time to speak to a solicitor? Because I'm dealing with all these other things and trying to address all of this. If they manage to get a solicitor, the solicitor is also making decisions about what cases can we take on here. Habitability cases, damp and mould, not covered. Hardly anything is happening because the lawyers can't take the cases on. So we have so few dealing with that kind of systemic nature of housing not being of a tolerable standard, and all the focus being on one area, and that's repeated across the different kind of social rights that we see. So it's about that broader picture as well.
No, thank you. I'm going to touch back on my next question about the bureaucracy and access. Dr. Marsha Scott from the previous panel said that even the United Nations has raised the issue of depletion of legal aid lawyers in Scotland. Professor Boyle, how can we talk about human rights approach to administrating legal aid when we have many layers of bureaucracy, like you've just mentioned, a lack of solicitors who are willing to take cases at legal aid rates, women not being eligible to access legal aid because they do not know their household incomes, and obviously difficulty in understanding cultural and language differences, which we heard from earlier on from the panel before. So just your thoughts on that?
Certainly, like I say, I think that the Scottish Legal Aid Board is on a learning journey in terms of trying to embed equality and human rights. And one of the reports that actually mentions legal aid is there to meet people's human and social rights. And that's a quote directly from them. But I think there's a mismatch, or it's between what the remit of a statutory body and what it thinks it's there, you know, what it is there to do, and what is actually happening in practice for people on the ground, but also how SLAB connects to other actors in that picture. You know, so there's more that could be done by the Law Society, for example, to encourage that broader curriculum. There's more that could be done by the government to, for example, address the regulations that Ben has already mentioned, cause a chilling effect on addressing civil injustice. But then there's this kind of, if you think about access to justice as a journey from the perspective of the person that injustice is happening to, there are so many barriers along that route. And legal aid is one of the key parts of that. But ultimately, you can't address all of the issues with access to justice with legal aid alone. So typically, in terms of a journey, a lot of the research and focus and what we think we need to do focuses specifically on advice, representation, and a well-funded legal aid scheme. But actually, we need to think about what happens. I use the analogy of a mountain range. So when people are about to embark on trying to access justice, they see this huge mountain peak, which is, we don't have all of these issues. We don't have the financial resources, and there's prohibitive costs involved. But actually, when you get to the top of that peak, you then see that there's another 5, 6, 7, 8 peaks in front that you couldn't see from the start of that journey. So if you think about it in the broad sense of an access to justice journey, the first thing that we don't have is an awareness of rights. So people not thinking about their legal needs as human rights and all the types of discrimination issues that can arise in that context. People don't have the resources, but it's not just financial, it's the emotional resources that are there that are required as well as the legal resources. So we need to have investment in a broader group of specialist lawyers, well funded in order to support people in these situations. And we also need to think about the emotional resources, which comes back to that idea of placing the burden on individuals to try and fix, you know, systemic problems for everyone. There's also fear of retribution, and I think that closely connects to some of the issues you raised, that we think that, you know, we're operating in this kind of hypothetical situation that people should be able to claim their rights, and that legal advice and assistance and legal aid is there to support them. But when someone complains or makes it known in any way that they have a problem or they have an unmet need, there is often retribution for that, which manifests itself in many different ways. And that's not built into the system. We have a very adversarial, you know, we have an adversarial system. Other countries deal with stuff in more inquisitorial ways to try and have a more people-centred approach. But retribution is a real fear, and retribution does happen. We have evidence to demonstrate that. We also have an incredibly complex system with many different paths to take. So, for example, you've got the Scottish Public Service Ombudsman, 12-month time bar, but if you need or require to access an effective remedy by way of judicial review, it's a 3-month time bar. And yet people don't have, they will not know this at the point in which they experience a human rights violation. We have what's called in the system administrative muds, and solicitors talk about this idea that you just get lost in the system via appeals mechanisms, the bureaucracy. So effective remedies in terms of timeliness and effectiveness are just not happening in practice because people are mired in this administrative mud. Basically, the system is not designed to meet human rights and people's needs. We also have these kind of systemic issues, and I would go back just to Regulation 15, and I think it's important, of course, that we have compliance with our house, but environmental rights are also closely connected to all those other issues that I mentioned. Economic, social, cultural, environmental tend to be interconnected, as well as civil and political. So there's really that broader set has to be addressed within the context of Regulation 15, but we need to think of ways of delivering collective justice mechanisms better, and then ultimately feed back into the system. We don't have feedback loops to correct these problems, and so you're seeing these repeated decisions and errors in the system, and public bodies are not getting a chance to learn. They're not getting a chance to reframe the ways decisions are made or find out what's going wrong, and that's really only the tip of the iceberg when I'm talking about between 50 and 70% of decisions being unlawful. You know, that's the people that had the resilience to get to that place and through sheer luck, to be quite frank, managed to find a solicitor to help them. So it's about entirely recalibrating the system to take a human rights-based approach, and there's so much rich evidence there to help support that. And in a sense, we're already so well equipped to move into that way of thinking, but it's about actually changing the aims and objectives of an organisation. It's about meeting needs, it's about meeting human rights, it's about addressing systemic collective injustice, rather than about simply focusing on audit, efficiency, saving money, because ultimately, if you start to address things more collectively, you do make it more efficient. So it's a bit of lateral thinking in terms of that wider societal role it plays.
No, thank you. That was really good detail there, Professor Katie. Dr Ben, would you like to add anything to that, or are you okay? That's fine. Thank you very much, Convener.
Thank you. That brings us to a close of panel 2. Are members content that they've asked everything that they wish to? Would the witnesses like to finish by including anything you feel that you haven't said so far?
No, thank you very much.
No, you're content.
Thank you.
Okay, that's great. Thank you once again for joining us this morning. We will now move into private to discuss the remaining items on our agenda. Thank you.